Looks like we're ready to go, Jenna.
Okay, thank you, Paul. Good afternoon and welcome to Legal Answers Live from Bay Area Legal Services. It's been a while since we've done one of these, but it's my pleasure to introduce Attorney Tom DiFiore today, who's going to be talking about tenant rights and landlord obligations in Florida. Tom came to Bay Area Legal Services in 1990. He manages our housing team. Tom earned a bachelor's degree from Georgetown University before graduating from the National Law Center at George Washington University. And Tom has led his team here at Bay Area for over 20 years. So thank you so much, Tom, for educating us today on this topic, and we really appreciate it.
All right, let me unmute myself. Thanks a lot, Jenna. My pleasure to join everyone here today. So as Jenna mentioned, I'm the head of the Housing and Consumer Unit at Bay Area Legal Services. For those of you that aren't aware, Bay Area does not ever charge a fee for our services. We have different funding sources that help us represent people when they're eligible for our services. So if you're in doubt and you have a question or a legal problem, call us up and we'll screen you for eligibility and see if we can help you out. I'm going to go through quickly, probably for 15 or 20 minutes, a quick little PowerPoint on Florida evictions, just an overview of the process. And once we do that, we'll leave some time for questions. We may have the end of the slideshow is a specific section on what happens after a hurricane or a storm and what your rights are, which may be of particular interest given the two storms that recently hit us. So next slide. So there are generally a couple of reasons for an eviction being filed against you. An eviction is a fancy word for the legal proceeding to remove a tenant from a house they're renting for a particular reason. The 80% of the time it's for failing to pay the rent. The other percentages are typically not following a particular lease term or violating a lease or not maintaining the unit according to the minimum required by law. So there's quite a few different various ways that a landlord can seek to have you removed from the property. We'll get into those now on next slide. And I'm saying next slide because I'm actually out of the state and I don't have control over this. So Paul is thankfully helping me and doing a great job, I might add. So what the landlords are not allowed to do, these are some of the things that landlords may try and do besides actually going to court to remove you. They're required under Florida law to take you to court to remove you from the property, but they may on their own try to take your doors off, mostly block the unit, maybe cut off the water or the electricity or the power. And this is not permitted under Florida law. Next slide. So if they did do something like that, there's generally a penalty of 3 times the monthly rent. The main part there where we get involved is to try and get the utilities back on or get you back into your property. But if anything like that happens, you can certainly call us or another lawyer of your choice. So what is the actual eviction process? This outlines it. There's a paper you get called a notice before the court paper, then the complaint. That's not like complaining about you don't like the temperature of your food. It's a legal complaint is the official term. Service or process. So that's a generic term. You've been served. Sometimes people hear people say that. That's the actual paper getting delivered to you. And then if you're lucky, and we'll get into that in a few minutes, you get a court hearing. And then if you prevail in court, you get to stay. If you don't, then something called a writ or an order of possession's entered. Next slide. So what is the notice requirement? So there's generally two different types of notices in general. The 3-day notice, like I mentioned, that's for non-payment of rent. And that's essentially 80% of the cases are non-payment of rent cases. If you get one of those, it's very important that you call us or talk to somebody with experience or legal knowledge to decide what to do. The main point is you need to offer any money that's owed that you admit is owed within that 3-day period, which doesn't include weekends and holidays. If you don't do that, then generally you don't have any defense to the eviction and you probably will be removed from the property in short order. So pay strict attention to that, even if a landlord says, hey, it's not that big a deal. It is a big deal, and a 3-day notice needs to be taken very seriously. The other types of notices for other than non-payment of rent, these are generally two types. One says you have 7 days to fix this problem, this violation of the lease. You have a dog there, get rid of the dog. You have a trampoline, you need to remove it. You have unauthorized guests, they need to leave, and it gives you a chance to fix that problem within 7 days. The other one is a 7-day notice without an opportunity to cure for more serious violations. This might involve threatening office personnel, uh, committing criminal activity or drug-related activity, something along those lines. And how do you get this notice? Generally, it can be hand delivered, mailed, or posted on your door. And generally, the landlord needs to have some proof of that notice being given. Next slide. So the complaint, we mentioned this earlier, the complaint is just a legal document that says you've done this wrong, either you haven't paid me or you violated the lease. The summons is the paper at the front of that. We don't really need to get into the non-military affidavit, I don't think. Essentially, the paper comes to your door and is either taped to your door or handed to you by a sheriff, a Hillsborough County sheriff, or what's called a process server. And a process server would be just a regular person, probably with some sort of a ID that hands you the paper. But you don't have to be handed the paper. They can just tape it on the door, unlike a lot of other legal actions. Next slide. So service, we could sort of skip over this. I think we just mentioned it. Basically, if you've got the paper, pay strict attention to it and follow the instructions on it. Read them closely, call our office or talk to somebody else about it. But generally, you're going to get handed that by a sheriff or a process server. It's going to be taped to your door. That's called service or process. Next slide. And these, when you switch the slides, they're going to be a little interesting. They had nice little features to them. We'll see that in a minute. What type of defenses are there? There's a lot written here, but essentially the main defense is, well, the amount you said I owe, I don't owe. And the most important thing that we can talk about today is this little purple box here at the end, which says the tenant must continue paying rent during the proceedings into the court registry. And you also must put the money owed into the court registry. Court registry is like a bank. So you can't just file a paper, say, I disagree with this eviction, and then wait 30 days for a court date before the judge. In other states, that's the case, but not in Florida. It's very important that you really need to put a reason why you don't believe the rent is owed. And there can be different reasons for that. Maybe there are not repairs being made and you told the landlord about it. In Florida, you have to hold that rent and not spend it and let the judge ask the judge to figure out how much rent is owed. Or, the notice may say you owe $2,000 and you say, oh, I only owe 1,000. So, but you have to put the amount of the rent in question, basically challenge it and put that into a paper to file with the court. The formal name for it is a motion to determine rent. And what this does is this stops, because after 5 days, if you don't, put the rent issue, make some question about what the amount owed, what amount of rent is owed, then what will happen next is on day 6, after the papers are given to you, not including the weekends, basically the judge will grant the eviction and you could be out within usually 3 or 4 days after that. So it's very important that you put something in your response that puts the amount of rent, a question mark behind it, that either that there's not repairs being made or the amount is incorrect. If you don't have anything to say regarding that, then there's really not a lot to do to stop the eviction, except maybe try and settle the case with your landlord. Let's go to the next slide and see what we've got. So if you put the money into the court registry that's owed, or you file this motion to determine rent, then you get a day in court. And in the day in court, the judge will have what's called a hearing. And then you go personally to that hearing, although sometimes they're done by Zoom these days, but most of them now are being done in person. The judge hears both sides, just like the court cases on TV, especially if you're unrepresented. The judge has to sort of take charge of the situation and do a lot more. If we're representing you, it's a little more formal. And if the judge agrees with the landlord, then he's going to issue a paper called a writ of possession to remove you. Um, if you uh, if you bring forth a defense and you win, then it's called a paper called a judgment for you is issued, and you get to stay. But if you don't file a response at all, which is why it's so important, generally you're going to be removed, and it doesn't even require a court hearing. That will be probably, you know, day 7 or 8 after the papers came to your house. So it goes very quickly in Florida. Next slide. Here comes the fancy ones. Yeah, little flip back. Writ of possession, there's a lot here. We don't really need to go into all this given our time constraints, but essentially when that paper is posted on your door, and hopefully it never is, but if it is, you need to pay very strict attention to it, because it in Hillsborough County anyway, it will give you 48 hours to vacate the premises. And if you're not out in those 48 hours, the sheriff will come stand by. They don't change the locks, they just stand by. And if you don't leave, if you refuse to leave, then that's the point at which the sheriff can forcibly remove you. So they're standing by to keep the peace while the landlord removes you, and also can remove your property from that home and put it on the street for anybody to take. So you don't want to get to the position where you're still there when that time runs out. In other counties, it may be different. In Pinellas or Pasco, the statute or the law itself says 24 hours after it's posted. So I can only speak for Hillsborough at this point, but it's a 48 here. I'm not sure about Pasco and Pinellas. Next slide. Yeah, the eviction, usually it's about $1,000 for a landlord to do an eviction, including hiring an attorney and all the fees involved in it. Um, Very, very important to try and, in the first place, avoid this paper called an eviction being filed, because once it's filed, it's in the public record essentially forever. Very difficult, almost impossible to have it removed. There are some very limited exceptions to that, but essentially, it's going to make it very difficult for you to rent in the future if you have this eviction, which is part of the public record, meaning anybody can look it up by putting your name into the court system's website, and it will pop up immediately. So communicate with your landlord, try and work out a payment plan or a deal if you can. Um, you know, Sometimes there's some rental assistance available. We have some of that. That we don't have the rental assistance, but we have access to giving referrals for that. So it is very limited, but there's other avenues of getting some rental assistance out there as well. But again, it's very limited. But the most important thing is to try and avoid it being filed. And if the eviction that is filed, then trying to work out something so that at least you can have a decent record behind you about what happened at that place. Next slide. And how does it show up in your record? As I said, it's public. It's on your credit report for up to 7 years. They can be reported on credit reports. It depends on the particular agency, although most court proceedings will show up on there. If you have any sort of a court action against you, criminal or non-criminal, it usually shows up in your credit report. And let's see what this says. Good practice to find out if you have a collection on your credit report prior to applying for housing. So it's always a good idea to check your credit report once a year anyway. And you can do that by going to annualcreditreport.com. not free credit report, annualcreditreport.com. And you have the right to get one. I think actually one of my advocates said that since generally it was once a year and there's 4 credit bureaus or 3. So you can do it like every 4 months, you can do all at once. Now I think you can do it more often because of COVID, but generally, once a year, once every 6 months, checking that anyway to be sure you know what's on there, that there's no fraud, that nobody's gotten a hold of your information. But that's where it would potentially show up. So again, it's something to try and avoid if you can at all. Next slide. Doing a time check here. We're at, let's see, 146. So getting eviction off your record, basically all but impossible to do in Florida, very difficult for a lot of different reasons. We've tried it and have not had much success with it. So again, the importance of not having that on there in the first place. Next slide. All right, we wanted to get into something here about casualty damage. So this is a part of the landlord tenant law in Florida that is particularly relevant, with the 2 hurricanes we had with Milton and Helene. So let's go forward with that. What does the landlord tenant law say about this? I'm not going to get into reading this slide. It's a little more complicated than we need to be, but essentially, if there's damage from a storm, you've got 2 options. You can ask for the lease to end completely, which is called total casualty, or you can ask for a reduction in your rent, which is a partial casualty. So it has to be substantial damage. What does that mean? I'd say generally like 50% of the property. It could probably be less, but depending on what it is, if a tree fell and you lost access to half the house or a bedroom, you could ask the landlord to reduce the rent by half. If like in these storms, I know a lot of places were flooded. If there's, 8 inches to a foot of water in your house, you're gonna have to vacate for the repairs to be done, but you can potentially negotiate with your landlord for a return. So the landlord tenant law says the tenant may vacate part of the premises rendered unusable by the casualty. So what this means is the landlord really can't demand that you leave. It's up to you to decide if you want to. Now that's what the law says as a practical matter. You're going to get a landlord potentially that's forceful about it and says you need to go. But that's something that you can call us about. But the law essentially says it's in the tenant's hands, not the landlord, to decide. But as a practical matter, if the house has been flooded, it needs to be repaired. In best case scenario, I guess you could be housed somewhere else temporarily, and when the repairs are done, get returned back in. Next slide. So casualty, essentially for our purposes, is a hurricane. It can be other things: burst pipes, loss from a flood, like we said, fallen trees. So next slide. Full casualty, there's a lot of verbiage here, but I sort of went over this. Essentially, we suggest it's not really explained how to do it in the law, but sending a written notice to the landlord saying, hey, this is what's going on. I want out of this lease because I can't live here anymore. I want you to return my deposit and we're all done. I don't owe you any more rent. And hopefully get a confirmation from the landlord that he's going to allow you to do that. If he doesn't, or she doesn't, he or she, the landlord, doesn't do that, then and they demand money from you, that would be something that maybe would be worked out in small claims court later. So you basically have 2 groups of tenants: one that want to leave because they know they can't live there anymore, and they want to be sure that they don't owe any money before they leave and that they have a good record behind them. That's where you would claim this full casualty. And on our website, I believe there's a sample notice for that, or you can call our office and we can get one to you to use for that, or a partial one. So go to the next slide, please. So partial casualty. So this is a little more complicated, a little more dependent on the particular, situation that you're in. We call the facts of your case in our profession. It's more fact intensive is the proper legal term. But so in this part, this was the example I gave. So a tree falls in the house, rainwater's coming in. It's limited to, 1 bedroom and 1 bath and 2 bedrooms and 1 bathroom and the kitchen are fine. So you can remain living there while it's being repaired. Maybe a tarp can be put on the roof and you wait around for a roofer to come. They can come in and, mediate the water damage, get it out of there, whatever it is they do to keep it from molding and things like that. And then you can say, well, I've only got access to what, half the house or a third of the house. So I'm gonna, instead of paying, 2,000 a month, I'm gonna pay you 1,000 a month. And if the landlord agrees, then you do that. You give them a written notice, basically saying that you can't repair the damage and then take it off your rent. You have to give the landlord this type of notice. And it could be negotiable. You could even talk to them beforehand and say, hey, I want to stay here while the repairs are being made, but I don't want to pay full rent. I think this is a good amount. You wait to hear a good amount from them, and then you agree to that and get it in writing after that. And you do it as soon as you want to know you want to remain and you have evidence regarding the damage of the premises. So sounds easy, but I'm thinking most landlords probably want tenants to vacate the property with the intention of rehabbing it if it's substantial damage, fixing it up, and then maybe even, having have the lease end and then jack up the rent, make it higher and have a new person move in. That's my suspicion that the average landlord might want to do that. Take it as an opportunity to increase the value of their property. If they do make new repairs, they may want to get a new tenant in with new rent, but that's where you need to know that you have a right to remain there and negotiate with the landlord for that. So what are some of the procedural issues? Yeah, the landlord may say, no, I don't think that's the right amount, or make some repairs and then ask for more rent. Or they may, if you don't pay your full rent, give you that 3-day notice for non-payment of rent and go and file an eviction. And then you obviously would have the potential to bring that up as a defense to the eviction. Hey, I gave you notice in writing about the casualty problem, the problem with the flooding, and I want you, Mr. Judge or Miss Judge, to determine what amount of rent I should owe. That goes back to bringing the amount of rent that's owed into, saying, I'm not sure what it is. And the I'm not sure what it is what will get you potentially a court hearing with the judge. If you just say, I don't want to be evicted, I lost my job and, I had to pay extra money for the hurricane, that's not going to do it. You need to get right at the heart of the amount of rent owed in any paper or response you file with the court. Yeah, and if you remain on the property, the other option would be to give what's called a 7-day notice. I don't really want to get into that too much now. That's a little trickier to do and has a lot more requirements to it. So if it's casualty damage or damage from a hurricane, this is probably the best way to go. Next slide. So conclusion on this, not real clear what the law means. You can basically try and negotiate something with the landlord is the best way to do it, and use, these provisions, this law as a guide to that, like sort of what I was mentioning, back and forth about what it's worth with the property and how long it's going to stay that way. So hopefully I think that's the last slide. Let's see. Is it, Paul? Yeah. So hopefully that gave you a little overview generally of landlord tenant law, from the time of an eviction onward, and then a little bit about what happens after a storm. There's a lot that can happen generally, before an eviction as well. So I don't know if there's any questions in the chat. We have at least, it looks like, about 10 more minutes or so for any questions. Let me see what's going on here. Anything we got?
I'm not seeing any questions right now,
Okay.
Tom.
All right. So essentially, just remember to, when in doubt, you can call our office. At a minimum, we can screen you and have you talk to an attorney on the phone about your problem and give you what we call advice or limited action, or just, like a brief amount of service. Sometimes we go to court and take cases, for on a longer basis. Um, and even if you're not eligible financially for our services, because we have guidelines that you have to make below a certain amount, um, we still may be able to refer you to different areas. There's websites about how to file an answer or a response to a complaint. Um, there's lots of other materials available that we may be able to help you with. I think our goal in the future is to have a lot more available to the general public. That's not really contingent on income. It can just be part of our website, and a lot of pro se materials, given the advances in technology. Pro se meaning without a lawyer, that you can at least try and navigate the system a little better with some guidance from that. So that certainly is something we're working on, and hopefully everybody is recovering from the storm that had damage, and know that we're available, and we have several outreach sites. I think that's on our website as well. But most of our initial calls come via the phone, although we do go out into the community in a lot of different areas as well. So you can check out our website, www.bals.org. And there's a lot of valuable information there. There's a landlord tenant guide on there that would answer multiple questions you may have, pre-eviction, post-eviction. And we're always trying to update our website and get it to be more so that anyone can get what they need from there. Pleasure speaking to whoever we're speaking to today. I'm just talking into my cell phone here, and I don't know who I'm talking to, but um, glad to have the time to speak with everyone, and hopefully that was helpful.
Thanks, Tom.
You got it.